on to other, I won't say bigger and better things, but a different agenda. We won't be seeing you again.
Yes.
Wish you well.
Thank you. Appreciate that. Have a good one.
Brings us to item 4 on the agenda, in the matter of Call Cavalier, Department of Public Safety and Corrections, Office of State Police, docket number 2157S. There are several motions that are pending. The first of which is a motion for contempt and for incidental relief filed on behalf of Call Cavalier. We have parties present.
Yes, sir.
And I understand, Ms. Kraft, that you have 3 separate requests relating to 3 separate, 2 witnesses and relative to the department. Let's break the arguments down one at a time, let the department respond, and then we'll move to the next one after that.
Not just the department, the individual.
And the individuals, I'm sorry, yes, and the individuals.
Right. I did not see anything from Mr. Turner. I don't know if I missed anything. Were there any findings?
There was only an email in which Mr. Turner had asked for an extension of time to obtain counsel and asked that his email be considered a motion to quash.
I don't know.
That's all it says.
Okay.
There's
I don't know if
nothing
there was
more.
any language in the email that I need to otherwise address. But
Let's see.
We're going to take the departments last. So, and I think we're going to take Contempt Reeves first.
So, Ms. Kraft, you want to look at the Jason Turner one after the
Sure.
argument? Okay.
Yeah.
Please.
Ready? This is Jill Kraft and Brett Conrad on behalf of Mr. Cavalier, who is seated here to my right. At our last
What
attempt.
Ms. Anderson may respond.
Oh, sorry. Yes, sir. At our last appearance, to begin one of the hearings as it relates to Mr. Cavalier, we had properly subpoenaed Mr. Reeves, Mr. Turner, and documents from the Louisiana State Police. When we showed up for the hearing, Mr. Reeves, Mr. Turner decided not to appear, having nothing except some sort of email about I have a vacation and a deposition, I'm otherwise busy. And at that point in time, I moved orally, as I'm permitted to do, to hold the 3 parties in contempt, focusing strictly on Mr. Reeves for the purposes of our request for contempt and for incidental relief. I will note that yesterday I sat through a legislative hearing at which time Mr. Reeves was held in contempt by a committee of the Louisiana legislature. That will be a proceeding, I believe, to the House of Representatives for a full vote and imposition of a fine if it is passed. Here, the issue is much easier. Commission Rule 13.13 allows for the subpoena of witnesses and production of documents. Under 1313A, that is accomplished under the power and aegis of the authority of the Executive Director upon a request, which we did on March 30th, 2022, more than 15 days before the anticipated hearing date. Under Subpart B, for all hearings conducted, no subpoena requested will be issued unless a written request, which we did for the issuance of the subpoena, is received in the office of the Executive Director no later than 15 calendar days. We sent our request on March 30th, 2022, and I would offer, file, and introduce the attachments to our memorandum in support of oral motion for contempt, among which is our original written request for the subpoena. The request for subpoena shall contain the name of the witnesses, street address at which they can be served, and a brief statement of what is intended to be proved by each witness. We complied fully with 1313. When we showed up here, and of course Mr. Reeves was served, when we showed up here on, I believe, April 14th, Mr. Reeves was simply not present. 1317 of your rules allows for there to be contempt for refusal to appear, refusal to testify, and for false testimony. Under 1313B, in addition to any other penalties provided by law, any person who willfully fails to appear in response to a subpoena or an order issued under 1313, or who willfully fails to answer any questions, produce records, etc., shall be held in contempt or may be held in contempt by this body. The contempt proceedings are filled in the Louisiana Administrative Procedure Act, as we pointed out, and also the Code of Civil Procedure. This body has the power and authority not just to hold somebody into contempt, but also to fine them or to impose any other actions it deems fit. In addition to those powers and authority, one of the actions that this body is specifically empowered to undertake is to prohibit the offending officer or person from serving in any capacity with the agency for a period of at least 10 years. This is serious stuff. The person that we subpoenaed is the former superintendent of state police. This is serious business. The primary issue, at least as it relates to this initial request, relates to my client publishing a book. He was later terminated for speaking out. The evidence that I understood, frankly, from hearing 4 high-ranking officials within state police say yesterday was that they began having meetings as it related to Mr. Cavalier, whom they characterized as the quote-unquote leaker. Not anything relating to the death of Ronald Green or the officers involved in that, no, but as it related to this man. The reason we subpoenaed Mr. Reeves, frankly, is as stated in our original subpoena request, was for him to testify as to how it is we got to this initial disciplinary action, a 200-hour suspension for Mr. Cavalier for writing a book. The answer to that question was revealed in the report that was issued by state police, where they combined the issue of, we're concerned about these leaks, we think Carl Cavalier did something bad. He spoke to the press about the killing of Ronald Green, and he also happened to write a book that we originally thought was critical of state police. I submit to you, if you cannot enforce your own subpoenas, as this body is charged with being the body overseeing state police, then these hearings mean nothing. Because what that means is somebody can come in and simply say, I have a vacation. I don't want to be bothered. I don't feel like I have to show up with a subpoena, regardless of the fact that we, the taxpayers, paid these people to serve as state police troopers. And when it comes to them subpoenaing, fulfilling their duties, and certainly testifying as it related to disciplinary actions initiated on his watch, he simply can just ignore it. That is why your rules under 1313 say if the information is pertinent, which it is. And under 1317, yes, sir.
Just briefly. So how is it that you contend that the discipline involved in the hearing we had scheduled arose under Mr. Reeves' command?
Because as I understand the testimony I heard yesterday and the original testimony before the legislature, what happened was within 1 week of Ronald Green's killing, they viewed videos. That was according to former Lieutenant Colonel Oliphant yesterday, Mr. Reeves, Mr. Oliphant, and others. The videos of the death of Ronald Green. At that point in time, they became concerned, fast forwarding into the spring of 2020, about, quote, leaks, which was Mr. Cavalier. According to the testimony I heard yesterday, they had meetings on a weekly basis, Mr. Reeves and the command staff, about Mr. Cavalier and the quote, unquote, leaks. That then began.
Do you believe that the discipline imposed in this appeal?
Yes.
Let me finish the question
Sure.
first. In this appeal is related to that.
Absolutely, 100%. And what happened was a cascade, and especially if you look at the report that they issued in their investigation, it was a cascade. They heard about some sort of book that Mr. Cavalier had written. That was at the same time they were looking at Mr. Cavalier for issuing statements to the media, for talking to the media, accusing Mr. Cavalier of being the source of quote-unquote leaks about the Ronald Green killing. And at all that time, they came in and initially said, well, we're going to go after him for the book, and then we're going after him for the leaks. But all of them were tied together, and certainly, Mr. Simeon, I will tell you that in the testimony that I heard yesterday, all of that began with command staff meetings at which Mr. Reeves was the presiding officer in as early as the spring of 2020. So yes, sir, I believe it is absolutely tied together.
When was the book published?
The late spring of 2020, and it wasn't exactly published. I know we're not here about the appeal, but the way that the book came into publication was Mr. Cavalier paid with his own funds a third party to print a book.
Self-published.
Right,
Yeah.
right. I mean,
That's all
he
the
didn't
time.
get any kind of advance. Nobody paid him cash.
Sure.
He actually paid them to print the thing. And then on Facebook, he proceeded to market the thing. But all of this happened at the same time. State Police's reaction as it related to Mr. Cavalier, as you can read in the notes and the reports and all that stuff, is an absolute fear that he's writing about State Police. What's interesting to me is nobody got around to reading Mr. Cavalier's book until way late in the ballgame, after they're sitting there bringing him in for internal affairs investigations about the leaks and all this kind of business that the command staff had decided would be their plan. And there's one, it's really funny, it's 2 sentences, 1 paragraph buried in the report where it says, somebody finally got around to reading the book and there's no reference to State Police. Oh. So I submit to you, the information sought from Mr. Reeves is pertinent under Rule 1313. Mr. Reeves took no steps to properly quash the issuance of the subpoena prior to the time it was required to be fulfilled on April 14th. And now this after-the-fact notion of coming in and saying, gee, I got this subpoena, I ignored it in the first instance, sorry for everybody's troubles, sorry for all the other witnesses who showed up here on the 14th, sorry I've inconvenienced everybody, but now I think it should be quashed because I don't think it's relevant. It doesn't work that way. I don't get to come in and blow off a deadline for complying with a subpoena and then a couple weeks later get around to saying, I just am not going to comply. I would ask under 1317 that you hold him in contempt as we requested originally on April 14th. Thank you.
We heard a lot of talk, no facts. Let's start simply. There wasn't any email. There was a very formal letter written to the commission. Ms. Meany can show it to you if she didn't already. It's my understanding, now I'm talking about what I've been told, I'm not able to tell you this directly, that letter was sent to Ms. Kraft with the assumption that she would contact me. The nexus of the letter, if you read it, I'm sure you did, gentlemen, is that Mr. Reeves does not know who subpoenaed him. He did not get the subpoena itself doesn't have these reasons that I have that are sent to Mr. Hanneman to be sent out. He did not know anything and does not know anything about the Call Cavalier disciplines that are before you.
Let me ask you a question. When you say that Colonel Reeves did not know who subpoenaed him, he knew he had a subpoena from this commission, right?
Yeah, and we inquired who was, we didn't even know who was at issue, what was at issue, you see? Now, he was scheduled to be out of town, and I was in court. Simple phone call from anyone could have resolved all this. Colonel Reeves wasn't trying to be in contempt of the hearing or not come.
Why didn't you file a motion to quash?
I didn't file a motion to quash because I presumed, Mr. Simeon, that I would get a communication. Actually, if you're willing to indulge me, let's be very technical. The only thing that happened involving this trooper, who Colonel Reeves has never had a conversation with. While Colonel Reeves was Colonel, was a 12-hour suspension for going to New Orleans to the cosmetology school. That was not appealed by Mr. Cavalier. That is the end of what Colonel Reeves had to do, or that occurred actually during his time with Mr. Cavalier. That suspension was delegated to Mike Noel in writing and signed off on by Mike Noel, who would be the appropriate party if you were going to ask questions about that suspension. Now, we didn't know any of that when this took place. I'm not telling you that we had the intricate knowledge that we have today. We just knew that we've gotten this subpoena, we have no idea what or why or for what reason. We have no knowledge that we can share with anyone relevant to the matters before you gentlemen. And that still stands true today. We're here. Now, according to Ms. Kraft's document she filed to quash Mr. Cavalier, a subpoena has to be relevant and the individual has to have knowledge for it to even be issued. Now, I don't know what, I'm just reading her brief. She says that's the rules. Okay. We filed a motion for today, asking you to not only not hold us in contempt, but to recall the subpoena, because there is not any grounds for this gentleman to be able to help anyone learn anything about this case. If the issue of the 12-hour suspension, which occurred under Reeves' watch, is somehow being used, we don't know, but I'm projecting, if somehow that would be made relevant some kind of way to the current discipline, whatever that may be, against Mr. Cavalier. The parties, the appointing authorities in charge of that decision are the people that should be before you. Colonel Reeves can't give you any information on that. He has none, and it would, all he would be doing is speculating on the judgment of some other person that's in charge of that job now.
I understand you said you're relying on Ms. Kraft's brief, but obviously it's pretty clear that at the time subpoena request comes in, Ms. Feeney, who issues the subpoena, will not know what the party knows or doesn't request. So she's going to issue a subpoena. She can't decide whether the person knows something and doesn't know something and then decide to issue or not issue the subpoena.
I appreciate that. What I'm referring to is, in the rules, I didn't have this. We didn't have this. If you asked why we didn't file a motion to quash, maybe I didn't answer your question. We didn't know that the reasons given for the subpoena, which are on the document, but we didn't get it, or as they listed. And I won't bore you with reading them, but I will tell you that had I had these, then, had I known this procedure and known that this was the issues that they believed Colonel Reeves could address, we certainly would have, very specifically, as I'm trying to do now, identified why we're of no value. You know, I don't think, I'm not making excuses, but sometimes people issue subpoenas thinking that they're going to need a witness for a reason or another reason, and they learn as they do their work that that's not going to, that particular individual is not the person you want. You know, I'm saying to you, Colonel Reeves is not the person you want on any of the disciplines that I'm aware of. And again, I rely on the state documents.
How do you address Ms. Kraft's point that the investigation relative to the publication of the book arose under Colonel Reeves' authority and was being done while he was colonel, and that is the issue in this particular case?
I don't agree that she's human right, but he's again not the right person to ask those questions. Okay? We're just doing this, gentlemen. There's a lot of theatrics going on in all this that are unnecessary. The suspension, you know, what Reeves was involved with was not appealed, period. So it's a dead issue. Whether or not other people wrote some report about the book, do you have the report? Do we? Have we been given any information to testify or even consider knowledge of that? No. This is the first we're hearing of it. Ms. Kraft just told you that she wants us held in contempt for not being here several weeks ago. Had we been here several weeks ago, according to her, she wouldn't have had anything to say to Colonel Reeves. She learned this, she claims, watching TV yesterday. Now, I don't know what she watched, okay? I don't know what she did at that hearing, but it's not relevant to us. We don't have that evidence. We didn't create that evidence. We aren't capable of discussing or opining about that evidence. We haven't seen that evidence. You know, we're here because we were asked, required to come to answer the question of whether we were in contempt. And I'm saying to you on that issue, I asked for the deference of the committee We tried to make communications. If that was poorly done, I'll take the blame for it. Truth is, however, that had we known what were the issues, we could have filed a valid motion to quash because we don't know anything about it. Now,
You
if we're
couldn't
going
file the motion to quash based on his unavailability, your unavailability.
well, I could have filed, I suppose so, Chairman, that I could have filed a formal pleading. I was thinking foolishly that if there was a problem with our unavailability, somebody would tell me, look, we really do need to have this hearing and you really need to be there. Now,
When did we get Ms. Oswald's correspondence?
It's attached to our thing as Exhibit D. It was a fax to the commission, and you had it stamped received April 11th.
And our hearing,
It was faxed at 4:35 on Friday, April the 8th, and then Ms. Gibbons, when she came to work on Monday, the 11th,
and the hearing,
retrieved it.
14th.
was on
14th.
2 days before the,
well, 3 work days, sure.
yeah.
Okay, now, but there's not, the last thing Kevin Reeves is trying to do is being condemned to the state police commission. He was colonel of the state police and he was retired with great honors after many, many years. And if we inconvenienced him, we apologize. Now, if there is going to be issue, as we just heard, then I would ask the committee to require Ms. Craft to send us a new subpoena for whenever those hearings are gonna take place. And identify what is this evidence that she's referring to. And give us some of it. Because Colonel Reeves is not in the state police anymore. He does not have access to state police records. He does not have access to state police proceedings and has no idea, as we sit here, gentlemen, what exactly she's talking about. So fairness would dictate that if she believes he is a relevant witness, we get the details of what that evidence is or what she's relying on. And then perhaps, Chairman Singer, I could file a legitimate, fact-intensive, law-intensive motion to quash, or simply appear and let Colonel Reeves give his testimony. Either way. But right now, we're unable to make any kind of comment at all about what Ms. Craft just said today that apparently occurred yesterday. And obviously, whatever did occur yesterday wasn't the basis for the reason she gave for the subpoena a month ago, because it hadn't even happened yet. So if we have a new reason for the subpoena, we ask for a new subpoena.
Ms. Craft, any response?
Yes. Mr. Reeves, as I understand it, testified before the legislature himself. Part of that testimony was his acknowledgement that he had received a letter written by my client about systemic racism within state police. That letter was filtered to Mr. Reeves through, I believe, Representative Jordan. In our reasons for issuing the subpoena to Mr. Reeves, we identified specifically what facts are to be proven by this witness. Mr. Cavalier did not violate policy. The discipline of Mr. Cavalier was not in good faith and arbitrarily capricious. Mr. Cavalier was disciplined in retaliation for his protected speech. Mr. Cavalier was disciplined in violation of his due process rights and civil service rules. Mr. Cavalier was not afforded prior notice and a reasonable opportunity to respond prior to imposition of discipline. The notion that there was some sort of fact sent.
Now, some of the procedural issues, the discipline came
I understand.
After.
But I still am entitled to demonstrate for this body that the discipline ultimately imposed on my client was both arbitrary and capricious and not in good faith.
I understand. I was really responding to the things
Understood.
and not having an opportunity to address. That would not have been under under Colonel Reeves, based on what you're telling us, you believe that
Yes.
some of the investigation may have been, and maybe there might be some, and I'm not making a decision on that, maybe some of that might be relevant, but the procedural stuff that happened later, obviously Colonel Reeves can't.
He was not there in 2021.
Okay.
But I do want to note for the record, under 1313, we requested the subpoena, we identified the reasons as we're required to, and all that's required is a showing that his testimony is pertinent. You don't get to walk into any court or this body or anybody else and say, I got a subpoena, which they admit they received and were served with.
Is there a dispute over the subpoena being served on April the 1st of 2022?
I don't think so.
The date you gave me, I can't agree with.
I'm looking at it.
Yeah, I'll accept whatever you say. This, you notice, again, just reading her document, what she asked of you guys, gentlemen, and Mr. Hanneman. She put to serve Colonel Reeves at the state police headquarters in Baton Rouge, which of course he is not now. But at some point, Chairman Simeon, at some point, he got a subpoena because that's how I knew to write the letter.
Right.
So we're not denying that occurred.
Is this in the record? The service?
I would add it to the record.
All right, I'll go ahead and add the
Well,
service.
we accept that it was.
Yeah, okay. All right.
My final point is this. We issued the subpoena properly. It was issued under 1313. It's this commission's subpoena. We identified the reasons. He was served. There was a fax apparently sent to the State Police Commission, which is noted received April 11th. There was a letter attached, which is 3 paragraphs from Mr. Oglesby. We never received it, nor were we copied with anything. There's no CC on it. There was nothing, and I'm telling you, we didn't get anything in our office. And to have this notion of, I'm just not going to bother to file anything because I didn't get this stuff and just not show up is not in keeping with the commands of the State Police Commission in overseeing state police. I get it, he's now retired, but that doesn't mean he gets a free pass from subpoenas. In fact, the rules clearly contemplate that folks who are not even officers within the state police agency are subject to both the subpoena and contempt powers. We'd ask that he be held in contempt. Thank you.
Can I ask you to do something? I think Ms. Feeney may have some information that's relevant to this notice issue.
I do think, well, after the fax came through, the fax from Mr. Oglesby to the commission was sent on the 8th of April at 4:35. Ms. Givens discovered it on Monday morning the 11th and called me, and my advice was for Ms. Givens to send it to both sets of counsel so that they would each have a copy of the LSP counsel, Ms. Holland, and to Ms. Kraft or Conrad. And I believe that was done, right?
Right before the hearing?
I mean, it would have been that Monday, the 11th,
Okay.
the day that Ms. Givens got the fax, so.
Is that the additional information that you want?
Yeah, so I just wanted to make clear that we wouldn't have known who to ask. You know, if I'd have known it was from Jill Kraft, I'd address it directly with Ms. Kraft.
The subpoena doesn't tell you who asked for the subpoena.
Nor that, and had I known, gentlemen, the reasons which were written down here.
Actually, it does say, it says to testify on behalf of the appellant, which is clearly indicated as Carl Cavalier. I mean,
I don't know who Carl Cavalier's lawyer is. Bottom line is, had I known whom it was, I'd have contacted the lawyer. So put that on number 2.
We accept your representation that you would have contacted Ms. Kraft if you knew her identity.
And the state.
And the state. And we also accept Ms. Gibbons's statement that she, on Monday morning, faxed it out to the relevant lawyers.
Thank you. And had I known the reasons, which I have in this document now, which were not part of this subpoena, I would have been more proactive, Chairman Simeon, in identifying why we didn't think it's properly sent to us, and I'd be here. I wouldn't have been doing this today. I'd have been doing it, or trying to do it at a different date when I could get time that you could give me.
And I guess that's what my concern is. You were practicing law about the same time I've been practicing, maybe a year or two or more. And we all know what a motion to quash is, but none was filed, none was requested, other than a letter sent 3 days, well, on Friday afternoon at 4 something, and we don't get until Monday morning for a hearing that's coming up in a couple of days, and that just gives me serious concern about why something more formal than that was not done in respect to this commission's authority.
Well, blame me, don't blame Colonel Reeves, all right? Whatever you want to look at that, all right? I'm not going to argue with you, and what I would do in my normal life is different perhaps than what someone else would do. So that's all. I can't say anything about that. If you think I should have filed a motion to quash, okay, I should have. Now, is he in contempt? No. Contempt Reeves is never intended to be in contempt. He's not in contempt. And I go back, if I'm not, to just in considering that issue, you can consider the whole finality of what's going on. This gentleman doesn't have, by the documents in this record, in Mr. Cavalier's record, Colonel Reeves doesn't have first-hand knowledge of any of the things that are before you, and is not the right person to have been subpoenaed if you wanted to get the first-hand knowledge. So, I just point that out because it seems excessive, if I may, to try to hold somebody in contempt when, had they come, their contribution would have been zero. You know? So there's no harm.
Mr. Ogle, those are matters that you could have brought up in your motion to quash instead of today. You could have provided that information. There are two different issues here. There's the issue of the subpoena being issued and ignored, and there's the issue of the suspension and material relevance to Colonel Reeves' participation therein. It's two different issues. We're looking at the issue of the subpoena itself, and the fact that this body issued a subpoena to Colonel Reeves and he didn't show up. And your statement a while ago about blame me, well, we can't blame you. We can't hold you in contempt. You weren't subpoenaed. So you're his representative. You've already admitted, or it sounded like, you should have filed a motion to quash. You did not. So in my opinion, you leave this body with little movement or ability to understand your relevance to his being a party to, or not being a party to, anything relevant to Mrs. Kraft's case and representing her client.
Well, I don't know if you're asking me a question. I don't want to say anything.
Maybe not. Maybe I was just making an observation. If there was something that I said that was incorrect, then please respond.
Well, no, I didn't know if you were asking me. I don't want to trespass on your time.
No, not at all. I mean, I'm just trying to summarize what I've heard this morning,
yes.
and if I'm incorrect about something on your client's behalf, then
yes.
Please.
I'm not saying you're incorrect. I'm trying to adjust your thinking, if I'm not.
That's fine.
This issue today, is about punishment. And I'm suggesting to you that punishment is unnecessary and would not be called for. These matters that you're talking about, the suspension, the knowledge, etc., I start with, in fairness to us now, because we're the ones that are asked to be punished. They start with a good faith basis for the subpoena in the first place. That doesn't make it okay. I'm not excusing it. But I'm also, if you will, if you think of mercy versus justice, okay? Their good faith basis for the subpoena, Commissioner, I'm saying it to you as straight as I can, does not exist. So, in terms of should Reeves be punished for not appearing, I wish you would take that into consideration. That's all. We're not trying to not come here. We're here.
Would you agree, though, that if every person that this commission subpoenaed took that stance that, hey, I'm not relevant to that case, I'm gonna ignore this subpoena and I'm gonna send the executive director a fax that says basically to that, then this body, to Ms. Kraft's point, would be moot. We've got to abide by the rules that we're given by the state, and that is that we have subpoena power, and then when that subpoena power is used by the body, that there is a proper response. The proper response is to show up. If the council believes, as you have very well articulated, I understand your position, but that should have been articulated in a motion to quash, and then you could have made those arguments. That didn't happen.
All right, now, can I ask for a little more leniency?
Absolutely.
This is just a suggestion. All this is about, I should have filed a motion to quash because I had a conflict for some reasons.
Let me stop you right there.
I should have.
That's not what it's about. It's about there was a subpoena issued by this body that was not followed according
I
to
understand.
the document. Well, don't misinterpret. You're saying that it's about your not filing a motion to quash. It's a very simple issue that we issued a subpoena. Your client didn't show up.
I was gonna make a statement, if you don't want me to, I won't. But I was gonna give you an idea of how you might, if you wish, address your concern about people that are not coming, et cetera. And if you would, indulge me for a moment, Commissioner, in the future, I would recommend that this part here witnesses what facts will be proved by this witness, which is written by the lawyer who issues the subpoena. If that was included, it would be very instructive.
And we appreciate your comment, and we'll consider that going forward, Mr. Oglesby, but that is not a current requirement for a valid subpoena, and it doesn't really go to the question of whether there was a valid subpoena and whether it was complied with. We agree on that, right?
Well, I'm not trying to lawyer this to death,
I don't know one who can do a better job of it than you.
I agree that a subpoena was issued, and I agree we got the subpoena, and I agree that, as all of you have articulated, the better thing to have done, rather than send the communication, was to put it sort of in a motion to quash. Now, you did make a good, you used the word valid. And that's a question I asked. And I'm not kidding. Under your rules, a valid subpoena has to have information of what facts this witness will be expected to testify to. Now, if in fact that's included, and if it's considered, and I'm not speaking to Mr. Hanneman, I don't know how that happens. I suspect probably somebody just sends it in and asks to send it out, and that's what happens. There's no conscious thinking about, let me look at the reasons for this and see if they're legitimate reasons. But if they're not legitimate reasons, now that we have them, and they aren't in this case, then is it, quote, valid? Now, I'm not trying to hide behind the tree on this. I'm taking the responsibility for it. I'm just saying that is a requirement. And since we don't, the validity word is in your rules, not mine. It's not like, where you just send the subpoena because you have a case. It's in the rules that you have to have a valid reason. I would think that goes not only to the person who wishes that the subpoena be served and has to show that valid reason, or at least articulate one, but also would be shared with the subpoenaed individual, so he could see if that is, am I the right guy? Was I at the corner when the accident happened? No. That's all I'm asking. Okay. Again, where we started. If the only evidence, apparently, that we've heard, that Colonel Reeves can speak to, if he can speak to anything, would have to do whatever Jill Kraft is discussing occurred at some hearing she attended yesterday. We're not prepared in any way, shape, or form to provide any information on that today. We don't even know what it is. So I would ask if it's easier to just do it in Stana, I don't care. We'll accept it and come back. What we need to have a basis for what is the belief that Colonel Reeves has certain evidence or information specifically to him that doesn't reside with the people who actually did it and are the best evidence, would be the best witnesses. We'll be glad to do that.
Do we have
But
a
I
date?
can't do it today.
Do we have a date for the hearing?
July 28th.
July 28th is the next hearing. Will you accept oral notice right here, right now, to work as the requirement that Colonel Reeves be here, unless you take appropriate steps between now and then?
Well, we'll be here, and if I take appropriate steps, I guess you'll decide if they're any good or not on July 28th. But yes, Colonel Reeves will be here on July 28th. We would ask,
What's that?
Well, yeah, never mind.
July
I mean,
28th?
you could have argued much of
July 28th.
That's the special hearing you said last, right? Correct.
Okay.
Yes.
So this matter is set for July 28th. We're not going to send out another subpoena for incurring additional cost. And he's under an obligation to appear pursuant to the previous subpoena based on the new date, okay?
we will do that, and I presume, Chairman, that whomever is wanting to ask Colonel Reeves about factual issues will make us aware of what they are, so that you're asking me if I can take appropriate steps. I can't take it in ignorance.
The appeal is a public record.
Yeah.
I think it
Right, I mean, Ms. Kraft gave you all kinds of reasons why she
Okay,
believes
that's
it's
it.
relevant.
All right, well,
I
we'll
don't know if
accept
there's
that.
anything else, but.
That's
the actual appeal document is a public record held by the commission, and you could obtain copies of the whole appeal, including the pre-disciplinary letter and the letter of discipline and the appeal itself.
And this information that I just heard is my notice of the issue. Is that correct? I'll accept it. I just want to make sure I'm listening.
Relative to, you have some basis to argue that the subpoena should be quashed based on that, then you have notice.
Thank you.
Any other commissioners have any questions? Commissioner Knapp?
Have we solved the issue about?
No, we haven't. We'll go into executive
Okay.
session to discuss
Okay.
that later. Unless there's, I take it this is all the submission related to this motion
Yes, sir.
for contempt relative to Colonel Reeves.
Yes, sir.
Thank you, Ms. Holmes. Thank you, Colonel Reeves. All right, we'll move on
Jason?
to the motion with regards to Jason Tucker.
You might explain to them that you're going to go into executive session at the end of all three.
Yeah, Ms. Dunn will speak. We're gonna go into executive session. Well, let's, I wanna do executive session after each one. Yeah, I do three. All right. So we're gonna go into executive session after we hear all three of these, and then after executive session, we'll come out for a public, discussion of what we discussed, so don't go away.
No, I'm not. I was going to ask something. We're coming back on July 28th. On July 28th, there'll be clarity as to why we're here. Why can't this issue be deferred until July 28th?
We'll discuss that in our executive session.
No, it's just a request.
No, I understand. That was gonna be part of what we would consider an executive.
Oh, all right.
All right. Mr. Lauren, make your appearance.
Oh, yeah.
Yes, my name is Jim Boren. I'm an attorney in Baton Rouge, 830 Main Street. I'm here as counsel for Jason Turner, who is also present.
Jill Kraft and Mr. Conrad again for Mr. Cavalier, who is seated to my right.
Thank you.
And Ms. Kraft, I'm gonna show you the
Thank
email.
you.
It's the same email from, I think, two different emails.
Okay.